Get to know the difference between replevin bonds and counter-replevin bonds. Here's a general overview of the two bonds. Before everything else, let us point out the difference between a replevin bond and a counter-replevin bond. A replevin bond allows the plaintiff to take physical possession of assets in question before the court begins the trial, while a counter-replevin bond allows the defendant to ask the court to be granted the right to take back possession of property taken or replevied by the plaintiff. Basically, a replevin bond allows the plaintiff to take physical possession of assets in question before the court begins the trial, and a counter-replevin bond is a defendant's counterpart to a plaintiff's replevin bond. What information is needed to obtain a replevin bond from a surety bond company? To get started, we generally need these things. 1. Completed application. 2. Copy of the court's final order approving the bond. 3. Copy of the complaint. 4. Financial statements are required if you are attempting to obtain this bond without collateral. What is my cost to purchase a replevin bond? If you are purchasing a replevin surety bond, you will pay the surety bond company a fee, also known as the premium. The premium is the monies that the surety bond company retains for providing you the bond. Generally speaking, for most court bonds, the premium is ordinarily pegged at 1% of the bond total with collateral or 2% without collateral. The minimum premium is $650. Is collateral required for these bonds? Broadly speaking, most civil or judicial bonds are required to be fully collateralized with a wire transfer of funds to our collateral account or an irrevocable letter of credit from a bank. The purpose of collateral is to protect the surety bond company from any loss. There are situations where we can approve the bonds without collateral, however, these situations will be approved on a case-by-case basis. In essence, a replevin bond is a plaintiff's bond, which is utilized by a plaintiff in a civil case. It is secured by plaintiffs who want to secure physical possession of disputed assets. It is required by courts before authorizing repossession of these assets. Before the start of a court trial, a plaintiff can post a replevin bond to demand the return of goods or property held by the defendant. By utilizing a plaintiff's bond, the plaintiff guarantees good stewardship of the assets until the court decides if the property should be returned to the defendant or not. Here is an example of a replevin bond in action. James and Clark have formed a trucking business. James used his truck as his capital, while Clark offered his real estate property as his share of the partnership. However, after several months, the company went out of business and the partnership was dissolved. However, James left the truck in the property of Clark, but he believes the truck still belongs to him as he was its owner. But James believes that the truck is now his property because he has unpaid salaries from the partnership and refuses to return the truck to Clark. Before filing his lawsuit, James, as the plaintiff, obtains a replevin bond from a surety firm that gives him the authority to retrieve the truck from Clark even before the case begins for trial. However, while the litigation is still pending, James cannot sell or dispose of the truck. He should also make an effort to keep the truck in the same conditions as when he took possession of it. But wait, courts not only require plaintiffs to issue a replevin bond. Defendants in these types of cases need a bond to counterclaim a replevin. In order to counter a plaintiff's replevin bond, counter-replevin bonds or the defendant's bond are secured by the defendant. It benefits the defendant because it allows them to retain control of the asset, but they are obligated to compensate the plaintiff for all the costs and damages on the property should the court rule in the plaintiff's favor. Are you in need of a replevin bond or a counter-replevin bond? Surety Bond Authority offers 100% free quotation and zero application charge. Call us at 800-333-7800, and our friendly and competent staff will be happy to assist you. You can also visit our website and get your free quote today.